Good evening, dear students. Welcome to Bajirao IAS Academy Current Affairs series for Prelims 2024. So, in the past lecture also we have discussed few important polity current affairs, and in today's lecture also we will discuss few more important polity relevant current affairs. Okay, so the overall objective of this program is to make sure that whatever questions are being asked from the polity point of view in the prelims examination, so you attempt those questions with much more confidence. And not just polity, we will also try to discuss all important current affairs for all other subjects as well. Okay, so let's start this discussion with the privileges and immunities which are being provided for the MPs and MLAs. So we all knew that the member of parliament or member of legislative assembly are actually given certain constitutional immunities as well as privileges. So firstly, we will understand there are few constitutional articles which actually provide immunities and privileges to the members of the parliament. So we'll also understand them. What are those immunities or privileges? Now, Article 105 Clause 2, so it actually provides immunity to an MP, and with respect to the MLA, member of legislative assembly, Article 194. Okay, so just remember Article 105 Clause 2 and Article 194 Clause 2 for MPs and MLAs. So they provide certain immunities for both MPs and MLAs. Now, what kind of an immunity? So immunity from the proceedings in any court for anything said or any vote given by him or her in the parliament or state legislative assembly, or any vote given by him or anything he said in the committees of the parliament. And so therefore the courts cannot hold any person or any MP, MLA accountable for their actions in the house. And apart from that, the courts cannot hold any person liable for any report which is being submitted in the house, either paper, vote, or proceedings in a publication by or under the authority of either house of the parliament. So this is essentially in line with the separation of powers. So even though Indian Constitution has not provided for the strict separation of powers, okay, so there is no strict separation of powers, but we have separation of powers. And Article 105 Clause 2 and Article 194 Clause 2, so both are in line with the separation of powers, where the court will not involve in the proceedings of the parliament or state legislative assembly. So therefore it comes under providing immunity to an MP or an MLA. So this is also part of an immunity or privileges which are being provided to the member of parliament or member of state legislative assembly. So this is essentially in line with protection of freedom of speech and expression of every member in the parliament. And at the same time, every parliamentarian, as a representative of the people, he represents their constituencies and the aspirations of the people to which they are representing. And apart from that, there is also another important article, that is Article 112 with respect to MPs and Article 212 so with respect to the state legislative assembly. So these articles also provide certain immunities and privileges. So the validity of any proceedings in the parliament, Article 212 for state legislature. So the validity of the legislative assembly and at the same time the parliamentary proceedings cannot be called into question in any court on the grounds of alleged irregularity of the procedure. Because now if you look at the legislature, whether parliament or the state legislature, so they have the ultimate authority to frame rules for their conduct. Okay, so what should be the procedure, what should be the rules? So those houses have actually given a certain powers by the constitution. So therefore there will be no intervention from the judiciary in the proceedings of the state legislative assembly and at the same time the parliament. So Article 112 and at the same time Article 212 actually dealing with these privileges for the state legislative assembly and at the same time the parliament. Now, the parliamentary privileges are essentially two different types. So one is individual privileges. Individual privileges are privileges which are actually enjoyed by individual MP or an MLA. And the second category is the collective privileges. So first we have individual privileges and then we have the collective privileges. Okay, so collective privileges actually means that the house collectively enjoy those immunities and privileges. So that is known as the collective privileges. So this is the difference between collective privileges and individual privileges. Now within the individual privileges, so there are certain specific privileges or specific immunities which are being provided by the Indian Constitution. So we'll understand what are those individual privileges which are being available or enjoyed by every MP and at the same time every member of state legislative assemblies. So the first individual privilege is that no MP can be arrested 40 days before the beginning and 40 days after the end of the parliamentary session. Okay, so this is essentially framed to ensure that the arbitrary nature of the government should not impact the parliamentary proceedings. Okay, so parliament as a house is very, very important because it holds the executive accountable. The Council of Ministers, if you can understand this, the Council of Ministers directly responsible to the lower house of the parliament. What is the lower house? So the lower house is the Lok Sabha, right? So the Council of Ministers collectively responsible to the lower house of the parliament. And at the same time, the other thing that you have to understand that every minister who is part of the Council of Ministers individually responsible to the president. And in fact, the lower house can introduce a no confidence motion. Okay, so no confidence motion can be introduced against the government. Okay, so that will lead to the dissolution or a fall of the government. So therefore, in this context, the lower house, especially the parliament, is responsible for holding the Council of Ministers accountable or holding the executive accountable. No MP can be arrested before or after 40 days of the assembly session or proceedings of the assembly, right? So in fact, Indian Constitution has also mentioned that there should not be more than 6 months of gap between two sessions of the parliament. So this is also you have to understand. Okay, so a parliamentary sessions usually takes place. Okay, so a winter session, monsoon session, right? So this is how the parliamentary sessions usually takes place. So therefore, there should not be more than 6 months of gap between two parliamentary sessions, and that is what the Constitution has mentioned about the parliamentary sessions. And the second privilege that the MPs and MLAs enjoy is that they have the freedom of speech. And in fact, as a citizen of this country, Article 19 of the Indian Constitution talks about freedom of speech and expression. So in a similar way, all the parliamentarians and MLAs were also given the freedom of speech in the parliament, and they'll not be liable to any proceedings in any court of law for anything they've said in the house or in a committee, or the vote they have given in the house or in a committee. So therefore, this is the second privilege that these parliamentarians and members of legislative assembly enjoys. So the third individual privilege that they enjoy is that they are exempt from the jury service during the session of the parliament. Okay, so they'll not be part of the jury service. Okay, so during the parliamentary session. Now a jury service is outdated, it is not being used now. Okay, however, they are exempted from this jury service during the session of parliament. So these are three individual parliamentary privileges. And next we'll discuss briefly the collective privileges which are being enjoyed by the parliamentarians. So parliamentarians enjoy both individual privileges and at the same time the collective privileges. As I have already told you, what are these collective privileges? Collective privileges means that the house, all the members collectively enjoy these privileges. Okay, so they are being enjoyed by the both houses of the Indian Parliament. So what are those both houses of the Indian Parliament? Both Lok Sabha and Rajya Sabha collectively enjoy these collective privileges. So apart from that, the state legislature, for example, in certain states, there are state legislative assembly and state legislative council also. Okay, so in India, we have 7 states where we have the legislative councils as well. So therefore, it is being collectively enjoyed by the both houses of the parliament and at the same time the state legislature. Okay, so that includes state legislative assembly and state legislative council as well. Okay, so it is also enjoyed by these collective privileges are also enjoyed by the members of both houses of the parliament, state legislature, and at the same time the officers. So what are these collective privileges? Some of the collective privileges include the right to publish the reports, debates, and the proceedings. Okay, so parliament or state legislature actually have the right to publish its reports, its debates, and proceedings. And secondly, right to exclude strangers from attending the proceedings of the parliament. So it is also one of its privileges. So this is collective privilege. See, understand, there may be a question that which of the following are the collective privileges, or which of the following are the individual privileges enjoyed by the members of parliament and state legislature. So you may get that sort of a questions. And even if you analyze the papers, the previous year papers of UPSC, so every year they have been asking such in-depth questions. So therefore it is very important that you should have at least a basic knowledge on these collective privileges and individual privileges and other polity relevant topics. So apart from that, the parliament or state legislature also have the right to make rules and regulations on its own procedure. Because see, Indian constitution talks about the separation of powers. Okay, so it talks about the separation of powers. So therefore constitution has also given certain powers and authority to the parliament or to the legislature to frame rules to regulate its own conduct. And after that, right to punish the members as well as the outsiders for breach of privileges. So any of the privileges, both individual privileges and collective privileges, so in case they are being violated, then the parliament collectively can take action against the members and even the outsiders who are actually responsible for the violation of these privileges. And this is another category of the collective privileges. And after that, it also prohibits the court inquiry into the house proceedings. So this is also in line with the separation of powers. So there will be no interference of the court or no interference of the judiciary in the matters of the legislature. So this is another collective privilege. After that, no arrest can be made without the permission of the presiding officer. So in case of a Lok Sabha, it is a speaker who is the presiding officer, and in case of Rajya Sabha, chairman is a presiding officer. Okay, so without the permission of the presiding officer, no member of the parliament or the state legislature cannot be arrested. So these are all the collective privileges and these are the individual privileges. So I hope you have understood these collective privileges and individual privileges. So essentially, these privileges are being extended to the members of the parliament to make sure they are being protected from executive and at the same time judiciary. Okay, so to maintain certain degree of independence. So that is also very important. Okay, so to protect the sanctity of the legislature. Right. So next, we'll talk about the no confidence motion. Okay, so this is also another very important topic. Okay, so no confidence motion is also very often in news, right? So in fact, Indian Constitution, Article 75, Clause 3 of the Constitution, so actually specifies, see, one thing that you have to understand, nowhere in the Constitution the term no confidence motion is mentioned. Okay, so nowhere this term is being mentioned, no confidence motion. So you have to be very, very careful here, because earlier there were questions asked by UPSC that no confidence motion was mentioned in the Indian Constitution. Now, not just no confidence motion, but even other terms also. So therefore, there is a tradition or trend from the UPSC asking the questions of this nature. Okay, so you have to understand that no confidence motion is nowhere mentioned in the constitution, but one exception is that article 75 and clause 3 of the Indian constitution specifies that the council of minister, we have the council of ministers. Okay, so the council of ministers are collectively responsible to the lower house or Lok Sabha. So I have already explained this previously, that the 15% of the members of the Lok Sabha can be appointed as the council of ministers by the government. So clear? Okay, so 15% of the members of the Lok Sabha can be appointed as a council of ministers by the government. Now the council of ministers collectively responsible to Lok Sabha. Okay, so all of them are collectively responsible to the Lok Sabha, and they are individually responsible to the president. So I hope it is clear for you. Now here Indian Constitution Article 75 Clause 3 says that the Council of Ministers are collectively responsible to the Lok Sabha. So therefore, for testing this collective responsibility, okay, so in order to test the collective responsibility of the Council of Ministers to Lok Sabha, the rules of the Lok Sabha or the rules of the lower house actually provide for a certain mechanism, and that mechanism is known as the no confidence motion. Okay, so to test whether the council of ministers are collectively responsible or not, we have a mechanism, and that mechanism is known as no confidence motion, and this no confidence motion is mentioned in the rules of the Lok Sabha but not in the constitution. So I hope you have no confusion in this. Okay, so it is being mentioned in the rules of Lok Sabha but not in the constitution. So therefore the procedure with respect to Lok Sabha, the no confidence motion procedure is actually specified in rule 198 of the Lok Sabha. Okay, so rule 119 of the Lok Sabha talks about the no confidence motion. So the no confidence motion is nowhere mentioned in the constitution, and even either a confidence or no confidence motion is not mentioned anywhere in the constitution. This is very, very important line that you have to remember here. Now after that, so we'll understand the procedure of no confidence motion. So how can it be moved? How can a no confidence motion can be moved, or who can move it? First we will understand this briefly. Okay, so who can move a no confidence motion? Now I'll tell you what is the purpose of moving a no confidence motion. See, I've already told you that this council of ministers collectively responsible to the Lok Sabha, and in case if the council of minister loses the confidence of the Lok Sabha, then the council of ministers can be removed through passing a no confidence motion, that the council of ministers no longer enjoys the majority or no longer enjoys the confidence of the Lok Sabha. So that is how the governments are being removed. And in fact in India also, at last time in 2018, a no confidence motion was introduced against the present NDA government. So therefore there were several instances where this no confidence motion was introduced, and there were also instances with the introduction of this no confidence motion, the governments also fell down. So we'll understand that briefly. So the procedure, what is the procedure and who can move this no confidence motion? So any Lok Sabha MP, so here you have to understand that parliament comprises both Lok Sabha and Rajya Sabha, right? So only Lok Sabha MP and that particular Lok Sabha MP have the support of at least 50 other Lok Sabha MPs. Okay, so 50 other Lok Sabha MPs, the support, so can at any point of time introduce a motion of the no confidence against the council of ministers, right? So this particular member of parliament, especially the member of Lok Sabha, only member of Lok Sabha, with the support of 50 more members of the Lok Sabha can at any point introduce a motion of the no confidence against the existing Council of Ministers. So that is how the no confidence motion can be introduced. The other thing that you have to highlight and understand here is that so it can be moved only in the Lok Sabha and only by the members of Lok Sabha, and it cannot be moved in the Rajya Sabha because Rajya Sabha has no role in removing the government. Because please understand, Indian Constitution Article 75 Clause 3 clearly states or clearly specifies that the Council of Ministers are collectively responsible to the Lok Sabha but not Rajya Sabha, and because of that reason the no confidence motion is not passed in the Rajya Sabha. Okay, so once the motion is moved by the member who submitted this no confidence motion, so the government will have to respond to the no confidence motion. Once this motion is submitted, once this motion is accepted by the House, then the government will have to respond on this particular no confidence motion. And apart from that, the opposition parties will also get the opportunity to speak on this no confidence motion against the government. And after a comprehensive debate on this no confidence motion is held, the Lok Sabha will vote on the no confidence motion. So, right, how can we decide that whether the Council of Ministers are actually enjoying the confidence of the Lok Sabha or not? So when we put this motion to vote, only then we will understand whether the Council of Ministers are enjoying the confidence of the Lok Sabha or not. So therefore, this no confidence motion will put to vote after these debates from the opposition parties and the ruling parties. So once this motion is passed, or if it is supported by the majority of the members of the House, then the no confidence motion will be declared passed. Okay, so the no confidence motion will be passed and it will remove the government. So that will lead to the resignation of the entire Council of Ministers. So if a no confidence motion is passed, then the government must resign. So for the removal of the existing government, the no confidence motion is introduced and passed in the Lok Sabha. Now, what were the earlier instances with respect to the no confidence motion? So as of now, there are 27 no confidence motions which are being introduced in the Lok Sabha since India's independence. Okay, so there are 27 instances. Please also understand, earlier also UPSC asked a question on the private members bill. Okay, so the same nature of question, private members bill. That private member bill was never passed in the parliament. So that sort of options or questions that UPSC has been asking. So therefore it is also important that you have to understand the previous instances of the no confidence motion. Now in India, especially after independence, the no confidence motion was introduced 27 times in the Lok Sabha, because it is only introduced in the Lok Sabha but not in the Rajya Sabha. And the first no confidence motion was against the administration or the first Prime Minister Jawaharlal Nehru. So that was introduced or presented to the Lok Sabha in August 1963. Okay, so now the last no confidence motion was introduced in 2018 against the present NDA government, and this is the brief history of the no confidence motion. And these are the prime ministers previously they have faced this no confidence motion. Now, so the other important topic is ethics committee in the parliament. So this was also in news. Why? Because of expulsion of the TMC MP Mahua Moitra from the Lok Sabha. So therefore ethics committee of the parliament is also very often in news, and there is also a chance that you may ask the UPSC may ask a question on the ethics committee of the parliament. Now the formation of the ethics committee of the parliament can actually be traced. So when it was formed, so it is very important that we must understand when the ethics committee of parliament is actually formed. So then we will understand what are its duties, what are its responsibilities. So we'll understand that gradually. But the formation of the ethics committee in parliament can actually be traced to a resolution, so which was adopted at the presiding officers conference, New Delhi, October 1996. Okay, so this presiding officers conference, New Delhi 1996, is the place where through a resolution this ethics committee of the parliament was formed. Okay, so that is how the origin of the ethics committee in parliament can be traced to. And in fact, in Indian parliament we have two houses, as I have already told you, that Rajya Sabha and Lok Sabha. So therefore each of these houses of the parliament have their own ethics committee. So there will be no single ethics committee for both Rajya Sabha and Lok Sabha. So Rajya Sabha will have its own ethics committee, and at the same time Lok Sabha will also have its own ethics committee. Now the ethics committee in Lok Sabha, it was first constituted in the year 2000. Okay, so in the year 2000 the first ethics committee in the Lok Sabha was constituted. So what was the composition of the ethics committee? The composition is that not more than 15 members, and those 15 members are nominated by the Speaker of the Lok Sabha. So that is how the ethics committee of the Parliament or ethics committee of the Lok Sabha is being appointed. Now what is the term of the ethics committee in Lok Sabha? So the term of the ethics committee is that they shall hold office for a term not exceeding 1 year. Now even if you look at the parliamentary committees, we have two different types of committees. So these are main committees. Okay, so one committee is a standing committee, one type of a committee is standing committee, and other type of committee is ad hoc committees, right? So these ad hoc committees are not permanent committees, but on the other hand these standing committees are known as permanent committees. Okay, for example, if I can tell you the permanent committee example, the Public Accounts Committee is a permanent committee, and Estimates Committee is also a permanent committee or standing committee. But on the other hand we have ad hoc committees. These ad hoc committees are temporary in nature. Okay, for example, Committee on Digital Payments is an ad hoc committee, right? So such ad hoc committees are being appointed time to time for the specific purpose. So once the specific purpose is done, or the objective is fulfilled, then there will be no ad hoc committees. Okay, so these are standing committees and ad hoc committees. So in fact this ethics committee is one of such standing committee of the parliament. So therefore what are the functions? Okay, so what are the major functions of this ethics committee of the parliament? So it performs the following functions. Firstly, it oversees the moral and ethical conduct of the members of the parliament. Okay, so it is very important that the conduct of the members in the parliament should be moral in nature, and their conduct should be ethical in nature. Okay, so it should not be unethical in nature, and they should not take bribes, or they should not go through the corruption. So therefore these ethics committees actually oversee both moral and ethical conduct of the members. Firstly, the second function is that it examines the cases which are referred to the ethics committee with reference to ethical and other misconduct of the members. Okay, so this is the second second most important function of the ethics committee. So the third most important function is any person or any member, so they actually make a complaint relating to the unethical conduct of a member to the committee. Okay, so for example, the colleague or any fellow member of parliament, so they can actually they can register a complaint against the unethical conduct of a member to the ethical committee or ethics committee. So fourth, in the case of ethics committee, only an MP can be examined for misconduct. No other person can be examined for the misconduct. So this is one thing that you have to understand here. Okay, so no outsider can be examined no other person can be examined, but only an MP can be examined for his or her misconduct. So here I have briefly given you about this different parliamentary committees. We have the financial committees. They include Public Accounts Committee, Estimate Committee, and Committee on the Public Sector Undertakings. They are financial committees. And apart from that, we also have 24 departmentally related standing committees, and then other committees also: Committee on Privileges, Committee on Ethics, and then ad hoc committees. They are temporary committees. Right. So the other important article is, other important issue is money bill. Okay, so money bill is also very important, because see, understand, in the year 2018 UPSC has asked about this money bill, and in your preparation it is very important that you go through all these previous year questions. Okay, so that you can get to know what kind of a questions that UPSC has been asking in the examination. So one such very important question which is continuously in news, so that is a money bill. Because in recent times there were instances where the government has been using this money bill route to pass the legislations or to bypass the Rajya Sabha. So why? Because the money bill is only introduced in the Lok Sabha. So money bill will not be introduced in the Rajya Sabha, it only introduced in the Lok Sabha. And once it is introduced in the Lok Sabha, so once a discussion takes place on this money bill, then this money bill will be passed on to the Rajya Sabha. Okay, so Rajya Sabha will also discuss this money bill, but Rajya Sabha have no powers to reject this money bill. Okay, so with respect to money bill, Rajya Sabha have no powers to reject this money bill. Either they can suggest recommendations. So for example, if Rajya Sabha has not taken any decision on this money bill within 14 days, then the money bill deemed to be passed by the Rajya Sabha. It is being considered as it is passed by the Rajya Sabha, even if Rajya Sabha has not taken any decision on the money bill within 14 days. Okay, so we'll understand this very briefly. Now this money bill is actually defined in the Article 110 of the Indian Constitution. So therefore this money bill is actually a type of legislation that relates to the appropriation of money from the Consolidated Fund of India. So in India we have the Consolidated Fund of India, and if the government wanted to take money out of this Consolidated Fund of India, then the government must introduce this money bill. Only then the government can withdraw money from the Consolidated Fund of India, and this is in fact the main fund of the government. So see, the Consolidated Fund of India is not at the disposal of the government. The government cannot withdraw money from the Consolidated Fund of India whenever it wants. Rather, it requires the approval of the Parliament, right? So that approval of the Parliament can be taken through this either money bill or the appropriation bill. Okay, so therefore the money bill, which is defined in Article 110 of the Indian Constitution, is actually a legislation, and that is related to the appropriation of money from the Consolidated Fund of India. So this Consolidated Fund of India is the main fund of the government. So I hope you have understood this. Now the Consolidated Fund of India or money bill actually related to the financial matters. The money bill specifically related to the financial matters such as taxation, public expenditure, and public debt. Okay, so it essentially deals with these things. For example, if government wanted to repay the public debt, then the government must withdraw money from the Consolidated Fund of India. And if government wanted to do a welfare expenditure, then it must withdraw fund from the Consolidated Fund of India. And taxation related matters, either imposing of new taxes or altering the existing taxes, everything can be dealt by the money bill. Okay, so under Article 110 of the Indian Constitution. So therefore, it is the Speaker of the Lok Sabha who recognizes the bill as a money bill. So please understand one thing, that the money bill can only be introduced in the Lok Sabha, and when it is introduced in the Lok Sabha, it is the Speaker of the Lok Sabha who actually decides whether a bill is money bill or not. Okay. So it is said that Speaker has the ultimate authority over taking a decision on any bill, whether it is a money bill or not. So that decision is taken by the Speaker of the Lok Sabha. So, if you can remember that the government has been facing allegations that the Aadhaar bill or Aadhaar Act in the year 2017 was passed by the government as a money bill or through the money bill route. So because of that reason also the government was criticized. See, why the government is choosing to pass a bill through this money bill route? Why? Because the government can easily bypass the upper house, that is Rajya Sabha. The government can easily bypass Rajya Sabha through this money bill route. So even though the Lok Sabha sent the bill, the money bill to the Rajya Sabha, but Rajya Sabha has limited powers with respect to money bill. Rajya Sabha can discuss the provisions of money bill, and at the same time Rajya Sabha can also suggest recommendations to the money bill. However, Rajya Sabha have no powers to reject a money bill. No powers to reject a money bill, and that is how the government has been choosing the money bill route to pass legislations. So it can overcome the upper house, or it can bypass the upper house, and at the same time there will be no large scale debate on such bills. And because of that reason the government has been choosing this money bill route to pass different legislations, and one such criticism was leveled against this Aadhaar Act. Now we'll understand the criteria, how any bill can be considered or classified as a money bill. So as I have already told you that Indian Constitution Article 110 actually defines any bill, or it deals with the money bill. Okay, so the definition under Article 110 of the Indian Constitution is actually means that money bills are those bills which actually contain only provisions dealing with all or any of the matters specified in Article 110 and subclauses. Now, what are the matters which are being specified under Article 110 and subclasses which can be considered as a money bills? So the first thing is that, so please understand, this was the question that UPSC has asked. Okay, so which of the following matters can be considered matters specified under Article 110, so that can be categorized as a money bill. Firstly, so any legislation which is dealing with the imposition, abolition, remission, alteration and regulation of any tax, so that can be classified as a money bill, and this is the first criteria to be categorized as a money bill. And what is the second criteria? The second criteria is that any legislation so which is dealing with the regulation of borrowing of money or the giving of any guarantee by the government. Okay, so we are actually regulating the borrowing through a legislation, first thing. And secondly, if government has been giving any guarantee, so then also it will be categorized as a money bill, and this will be the second criteria to be classified as a money bill. And third category is that custody of the consolidated fund or the contingency fund of India, the payment of monies into or withdrawal of monies from any such fund. So this will also be classified as a money bill. And after that, appropriation of monies out of the consolidated fund of India. For example, so the government wanted to make a welfare expenditure. So the government wanted to repay a debt. So then the government must pass the appropriation bill to withdraw funds out of the consolidated fund of India, and that will also be categorized as the money bill. So that will be the third category to be classified as a money bill. And fifth one is that declaring any expense to be expenditure charged on the consolidated fund of India, or increasing the amount of any such expenditure, and that will also be considered as a money bill. And after that, the receipt of money on account of consolidated fund of India, public account of India, or custody or issue of such money, the audit of the accounts of the union and state. So all these things can be classified as a money bill. Okay, so all these things can be considered as a passing of a money bill. So therefore, a bill which has any provision other than money provision, so as mentioned in subclauses, is not a money bill. Okay, see, understand one thing, that a bill which is not containing any of these clauses, any of these provisions, so that will not be considered as a money bill. But any bill which is having any of these clauses, so that will be considered as a money bill. And in fact, the Indian Constitution has given the power to the Lok Sabha Speaker to take a final call if any question arises whether a bill is money bill or not. So the decision of the Speaker is final. Okay, so it is the Speaker who is the ultimate authority to decide any bill as money bill or not. And in fact, Constitution itself has given the power to the Speaker of the Lok Sabha. So therefore, in this context, Speaker's decision on this money bill is final, and it cannot be challenged in any court of law. And because of that reason, the government has been arbitrarily using the money bill route to pass the legislations to overcome or to bypass the upper house. And in fact, Rajya Sabha also has the limited powers with respect to the money bills. And at the same time, Lok Sabha has the supreme power in terms of these money bills. No supreme power, so the ultimate authority to pass money bill actually lies with the Lok Sabha, but not with the Rajya Sabha. Now there is also a procedure for passing these money bills. Okay, so what is the procedure that is being used to pass a money bill? So I've already explained you the procedure. Okay, so we'll try to understand the procedure for passing such money bills. Now understand, money bills are actually introduced in the Lok Sabha with the President's recommendation. So before introducing these money bills, recommendation of the President is very, very important or very essential. So President must recommend introduction of such money bill. Okay, so therefore money bills are being introduced in the Lok Sabha with the President's recommendation, and they can only be introduced by a minister, not even a private member. See, these things are very, very important. Please pay attention to this, that the money bills can be introduced only in Lok Sabha, only with the previous consent or previous permission of the President. And at the same time, only a minister can introduce a money bill. Now, who is a private member? Who is a private member? Private member is any other member of parliament who is not part of the Council of Ministers. So, okay, so even any MP from the ruling party can also be a private member. Okay, so therefore, any member of parliament apart from or who is not part of the Council of Ministers is considered as a private member, and therefore the money bill can only be introduced by the minister but not a private member. Okay, so once it is being introduced in the Lok Sabha, the bill will be sent to the Rajya Sabha for its consideration. So this will be the second step. Okay, so when it was introduced in the Lok Sabha, the bill will be discussed, and then it will be passed on to the Rajya Sabha for its consideration. However, I am reiterating this again that Rajya Sabha has limited powers and must return the bill within the 14 days to the Lok Sabha. Okay, so first Lok Sabha and then the bill will be sent to the Rajya Sabha, and within 14 days the Rajya Sabha must send the bill back to the Lok Sabha. Okay, so it can discuss and it can even suggest recommendations to the money bill. Okay, so therefore the other thing is that Rajya Sabha cannot reject the money bill as well. So therefore Rajya Sabha has limited powers with respect to this particular money bill. The Lok Sabha can actually accept or reject the Rajya Sabha's recommendations. Okay, now understand that Lok Sabha passed a legislation. Lok Sabha actually sent the money bill to the Rajya Sabha, and Rajya Sabha can send back the money bill to the Lok Sabha, so with some recommendations. Okay, so these are the recommendations. Please include these recommendations also in this money bill. Now it is the prerogative of Lok Sabha whether to consider those recommendations or not. So therefore Lok Sabha can either accept or reject Rajya Sabha's recommendations. Okay, so and if accepted, the bill will be considered to have been passed in this modified form, and at the same time the Lok Sabha has more powers regarding these money bills. So either the Lok Sabha can accept the recommendations or altogether reject all those recommendations, because Lok Sabha has more powers with respect to money bill. Then once it is passed by both houses of the parliament, it will be sent to the president for his or her consent. So therefore president can give his assent to the bill or withhold his assent to the money bill. So either he can give his assent to the bill or withhold his assent to the bill, but he cannot return the bill for the reconsideration of the house. Okay, so there are certain bills, so those bills can be returned for reconsideration by the president. But with respect to money bill, the other thing that you have to understand here is that so he can either withhold his assent and at the same time give his assent to the bill, but he cannot send the bill to reconsideration to the houses. So this is important things with respect to the money bills. The other important aspect is the powers of the governor with respect to the bills passed by the state legislative assemblies. Now why it is in news? So what was the context that this is being asked? So recently in Tamil Nadu and even Kerala, what was happening was the state legislative assemblies have actually been passing laws. They actually passing the bills, and the bills to become acts, so those bills must be given assent by the governor of a respective house, but governors have not been giving those assent to those bills. So they are holding those bills indefinitely without taking any action on those bills. They're just sitting on those bills. So if they don't give assent to those bills passed by the state legislative assembly, which is democratically elected, okay, so here the governor has not fulfilling his constitutional responsibilities. So therefore recently Supreme Court has ruled that governors are not empowered to keep a bill pending indefinitely without any action whatsoever. Okay, so governors are not constitutionally empowered to keep a bill pending for an indefinite period of time. And apart from that, the Supreme Court has also stated that governors are actually entrusted with the constitutional powers. So they actually have certain constitutional powers, but they cannot use those constitutional powers. They cannot misuse those constitutional powers which are being given to them in order to stop the normal process of lawmaking by the state legislature. So this is what the Supreme Court has actually said. Now in this context, we'll briefly understand the governor's legislative powers, that what are the powers that governor has. So Indian Constitution Article 200 actually states that when a bill is passed by the state legislature, now understand this, See, when any bill is passed by the Lok Sabha and then Rajya Sabha, and the bill will be sent to the president for his or her consent or assent. So when they give the assent to the bills passed by the parliament, only then it will become an act. So therefore, Indian Constitution Article 200 specifically states that when a bill is passed by the state legislature, then it will be presented to the governor for their assent. And the governor here have 4 options. Okay, so what will be the response of the government? Okay, what will be the response of the governor? The governor actually have 4 options on this bills which are being passed by the state legislature. So the first option is that the governor may grant his or her assent to the bill. So this will be the first option. The second option is that they may withhold the assent to the bills. So this will be the second option. Okay, so they will not give assent to the bills, they just withhold their assent. And third option is that they return the bills for the reconsideration of the House. And fourth option, they actually reserve the bill for the consideration of the president. Now here the main question is that, is there any time limit within which a bill should be returned by the governor? Okay, so the constitution was actually silent on this. So constitution has not mentioned any time limit within which the bill must be given assent by the president or bill must be returned for reconsideration by the governor. Okay, so that is the key issue here. So Article 200 actually states that governor may as soon as possible return the bill other than the money bills. Now see, in a previous money bill that we have discussed, that money bills cannot be sent for the reconsideration of the House. President may give his assent to the bill or withhold his assent to the money bill, but he cannot send the money bill for the reconsideration. So in a similar way, so with respect to a time limit for withholding assent by the governor, it is generally said that Article 200 states that the governor may as soon as possible return the bill other than the money bills. So as soon as possible, he must return the bill for the reconsideration of the House, requesting the House to reconsider it in parts or whole. Secondly, if state legislature sends the bill again with or without any modifications or any amendments to the bill, then the governor is obligated, or he is under the obligation to give his assent to the bill. So he must give his assent to the bill once it is again sent by the state legislature to the president, to the governor. And in fact, the court's judgment actually stated that the expression as soon as possible actually conveys a constitutional imperative of expedition. Okay, so he must send the bill for the reconsideration as early as possible or as soon as possible. Rather, the governor should not sit on the bills indefinite period of time, because that actually deviating the overall role and responsibility of the legislature and at the same time the democratically elected government. Now here, when can a governor reserve the bill for the consideration of the president? Okay, so the fourth criteria, if you look at this, the governor under Article 200 may also reserve the bill for the consideration of the president. So therefore, when can a governor reserve the bill? So there are also few instances. Okay, so in these instances, the governor can reserve the bill for the consideration of the president. Okay, so what are those instances? Firstly, the state legislature passes any bill so which is contrary to the previous rulings of the Supreme Court, and at the same time any legislation passed by the state legislative assembly which reduces the powers of a high court. So if it is reducing the powers of the high court, or if it is against any previous rulings of the Supreme Court, then the governor must reserve the bill for the reconsideration of the president. First thing. The second thing, the bill which is being passed by the state legislative assembly, if it is against the provisions of the constitution, especially the directive principles of state policy. In that case also, governor can reserve the bill for the consideration of the president. The third criteria is that if the bill is against the larger interest of the country. So if it is against the larger interest of the country, or it is of a grave national importance, then also governor can reserve the bill for the consideration of the president. And after that, any bill which deals with the compulsory acquisition of the property under Article 331A of the Constitution. So these are 4 instances during which any bill can be reserved for the consideration of the president. So I hope you have understood this Article 200 and governor's powers with respect to this. And another very important thing that is very often in news is with respect to forum shopping. Okay, so we'll understand what exactly is this forum shopping in a very brief manner, because UPSC may ask a question on this forum shopping. So forum shopping is very often in news is related to which of the following things. So just try to understand this. So recently, the Chief Justice of India denied permission for forum shopping. Okay, so a litigant who is appearing before the Chief Justice of India and seeking this forum shopping. Okay, so please understand what exactly is this forum shopping. So forum shopping actually means that the litigants or a petition is being filed, the respondent and the person who actually filed a petition, so they are known as litigants. Okay, so both litigants and lawyers are deliberately try to move their case to a particular judge or a particular court throughout the country. Okay, so for example, there was a case and they are trying to move that particular case to any judge or to any court, expecting that, so what they are doing, that they are expecting that this would turn the judgment in favor. Okay, so they are expecting that if this particular case can be taken to another court or to another judge, that the judgment would come in their favor. Okay, so just go through this definition. So any litigant or lawyer, they are deliberately try to move their case to a particular judge or to a particular court, but they are expecting that this would turn the judgment in their favor. Okay, so that is known as forum shopping. So there are 2 types of forum shopping: domestic forum shopping and transnational forum shopping. So when we talk about the domestic forum shopping, so when a litigant chooses between 2 or more courts within a country. Okay, so when litigant chooses 2 or more courts within a country, so that will also be considered as a forum shopping. Now after that, transnational, when a litigant actually chooses between courts of 2 or more countries, so that will also be considered as a transnational forum shopping. Now what are the global trends with respect to this forum shopping? In fact, US and UK courts have criticized the practice of forum shopping as something to be avoided or prohibited. Okay, see, because it actually deviate the overall purpose of judiciary, right? So that in an expectation of getting a favorable judgment in one court or with a one judge, so what you are actually doing is manipulating the process or the procedure of justice. Okay, so therefore this forum shopping is being criticized. Okay, so forum shopping is something that must be avoided or prohibited. And secondly, Indian judiciary has also condemned this practice of forum shopping and termed it as abuse of law. So this will actually leads to the abuse of law, and that is what the Supreme Court has said. And another important topic is National Judicial Data Grid or portal. Okay, so this National Judicial Data Grid or portal is that it is a real-time data on the filing, disposal of cases in the Supreme Court, and in fact it is now being available through the National Judicial Data Grid. Now the number of cases filed in the Supreme Court and number of cases which are being disposed of, so everything is clearly available at this National Judicial Data Grid. Now in judiciary, the problem is that a huge pendency of the cases. The huge pendency of the cases is the main challenge in the Indian judiciary. So in order to overcome this problem, so when we have a comprehensive data, and when we are able to track those cases, we get to know about the real-time situation, or real-time tracking of those cases. So appropriate actions or appropriate policies must be brought in to reduce the challenges. So this National Judicial Data Grid Supreme Court of India portal would include the following data. Now what kind of a data it actually includes? So it actually includes the current pending cases, that includes both civil and criminal cases, and cases filed and cases which are disposed in previous month. So it also includes those cases, a number of cases which are pending before 3 judge, 5 judge and even 9 judge benches of the Supreme Court. So these things are actually available in the National Judicial Data Grid Supreme Court of India portal. Now we'll understand this in a very detailed manner. So this is a national data repository. Okay, so it is having all the data with respect to the cases, and this repository actually aligned with the National Data Sharing and Accessibility Policy. So that was created in 2015 under e-courts project. Okay, so please understand that this particular national data repository, National Judicial Data Grid, so it is actually aligned with a certain policy framework. The policy was National Data Sharing and Accessibility Policy, created in 2015. Okay, so this policy was created under e-courts project. So therefore National Judicial Data Grid actually contains the details of orders, cases, both civil cases and criminal cases, judgments of the district, subordinate courts and high courts. Okay, so all these details are actually provided by the National Judicial Data Grid. So therefore it provides or allows real-time data updation, so by connected district and taluka courts. And apart from that, this National Judicial Data Grid was built as part of phase 2 of the e-courts project. So we have understood that e-court project was launched as part of National Data Sharing and Accessibility Policy. So please understand, these are minute details that you may get questions on this. And apart from that, this National Judicial Data Grid, so which was part of e-courts project. So this e-courts project is actually a centrally sponsored scheme. So who are being the developer of this National Judicial Data Grid? National Informatics Center and Computer Cell Supreme Court Registry are actually the developers of this National Judicial Data Grid. So we'll also talk briefly about this National Informatics Center. So this National Informatics Center was established in 1976, and it was also under the Ministry of Electronics and Information Technology. So it is also known as MeitY. Right. So next we'll also understand briefly about this e-courts project. So what exactly is this e-courts project? So this is e-courts mission mode project, and is a centrally sponsored scheme that we have already understood. So this e-courts mission mode project was launched in the year 2006, and it is part of the National E-Governance Plan. And apart from that, the Department of Justice, Ministry of Law and Justice is actually funding and monitoring this e-courts project. Okay, so Department of Justice, Ministry of Law and Justice is actually the funding and also monitoring the e-courts project for district courts across the country. Now implementation responsibility would be fell upon the Supreme Court. So Supreme Court is actually responsible for its overall policy planning and strategic direction of this e-courts project. Now how it is being implemented? So phase 1 was launched in the year 2007. So in the year 2007 phase 1 was launched. So during this first phase, the computer server rooms, judicial service centers were actually prepared for the computerization of district courts, and at the same time district court websites were also launched in this first phase of e-courts project. And it actually has 3 phases. So in the second phase, it was approved in the year 2015. So second phase was approved in the year 2015. And during the second phase, the uncovered courts of phase 1 and newly established courts were provided with new hardware systems per courtroom and LAN connectivity also. So after that, the National Judicial Data Grid was also launched. So this National Judicial Data Grid was actually launched for providing case details and at the same time status online of all the district and high courts of India. Okay, so we have also discussed about this National Judicial Data Grid. Now, National Judicial Data Grid was launched, in the second phase of the e-courts project. And this National Judicial Data Grid actually provide a case details and the status of those cases online for all district courts, high courts. So phase 3 was recently approved by the government. So therefore it proposes to usher in a regime of maximum ease in justice by moving towards digital, online, paperless courts through digitization in the entire country records. And these are the 3 phases of the e-court mission mode project. So another very important scheme, that is Nyaya Bandhu program. Now what exactly is this Nyaya Bandhu program? So this Nyaya Bandhu program was launched in 2015 by National Legal Services Authority Act. So this NLSA, so this was also known as NLSA or National Legal Services Authority. So it provides free and equal legal aid. Okay, so you may have come across Lok Adalat, okay, for the speedy disposal of cases free of cost at the local level. So NLSA actually provide free legal aid or equal justice to the marginalized sections through these Lok Adalats. So therefore the National Legal Services Authority Act launched this Nyaya Bandhu program in the year 2017 for the access of justice or ease in access of justice. So therefore it actually provides, the Nyaya Bandhu program provides legal aid in variety of areas including civil, criminal and family law. This program provides legal aid to people who are facing discrimination. For example, people from the lower caste, scheduled tribes, or even any other discriminated people. People with the disabilities are also being discriminated. So therefore this also provides legal aid to the people who are facing discrimination or who are being denied their basic rights. For example, bonded labor. So their basic rights are being denied. And apart from that, it is actually a mobile application, and this particular mobile application provides the pro bono legal services. Now what exactly is the pro bono legal services? It is for the public good, it is for the larger public good. So therefore this mobile application provides pro bono legal services to the people who are unable to afford the legal service and at the same time cannot access legal aid. Now how can this be used? So using this application, practicing lawyers will be able to register themselves, and they also can connect with the registered beneficiaries through this mobile application. And at the same time, they can also provide them services free or at a minimal cost and present them with an opportunity to address the legal problems meaningfully. Okay, so it also provides a feature of tracking the case status. And apart from that, to utilize the scheme optimally, the Department of Justice under Ministry of Law and Justice has actually proposed setting up certain pro bono panel of lawyers at each high court so that they can provide those services, or they can provide the legal aid for the needy people at a minimal cost or at a free of cost. Okay, so next important scheme is Disha scheme. So Disha scheme is also related to the delivery of justice. Okay, so this scheme was launched for a period of 5 years, 2021 to 2026, to advance the cause of access to justice. So this is actually providing justice for the people. So particularly with respect to Article 39 Clause A of the Directive Principles of State Policy. Okay, so this Disha scheme actually aims to design and consolidate various initiatives to provide citizen-centric delivery of legal services. So this provides citizen-centric delivery of legal services. And there are 3 components under Disha at present. So what are those 3 components? So they include Nyaya Bandhu program, tele-law, legal awareness programs. So everything comes under the Disha at present. Okay, so these are very important aspects which are in news. Okay, so there may be chance that UPSC may ask questions on these current affairs from the polity section. So we'll also discuss the remaining topics as early as possible before your prelims examination. And that's all for today, and thank you so much for being with us. Please subscribe our YouTube channel and also hit the like button. Thank you.